Thank you very much for inviting me tonight, and thank you for the very kind introduction. By the way, my daughter did go to NYU undergrad, so I have lots of purple clothing. Sorry I didn't come here for law school. Looking at the audience, some of this will be stuff everyone knows. Some of it may not be stuff some people know. Hopefully I can give you a few insights that are unique from my perspective about these two cases I'm going to talk about tonight, Corwin and the Trulia case. In October 2015, the Delaware Supreme Court issued its decision in Corwin, and it holds, and I'll just quote it, the business judgment rule is invoked as the appropriate standard of review for a post-closing damages action when a merger that is not subject to the entire fairness standard of review has been approved by a fully informed, uncoerced majority of the disinterested stockholders. That decision gave birth to what practitioners now refer to as Corwin cleansing, a doctrine that provides a potential off-ramp for early-stage dismissal of post-closing damages cases challenging M&A transactions that don't involve a controlling stockholder. In January 2016, about 3 months after the Supreme Court's decision in Corwin, I issued what's called the Trulia decision. It was like a online real estate company, in response to the proliferation of disclosure-only settlements we were seeing in the Court of Chancery. Trulia did change the paradigm in Delaware with respect to deal litigation. It sent a message that the court would be more rigorous when evaluating disclosure-only settlements, and it expressed a preference that disclosure claims either be litigated or mooted as opposed to being presented to the court in a non-adversarial settlement process. Now, it's been about 4 years since Corwin and Trulia were decided, and I believe it's fair to say they have changed. They've had a significant impact, in fact, some would say a profound impact on the deal litigation landscape. And so that begs the question, what have we learned over the last 4 years now that we have a lot of law that has developed since that time? And that's really the question I want to explore with you tonight during the time I have. So there are going to be essentially 3 parts to my talk. First, I want to explain some of the background of the Corwin decision itself, and then we'll discuss how the courts have applied the doctrine over the past 4 years. Second, I similarly want to provide some background on the Trulia decision, and then we'll discuss the trends we have seen in the pursuit of disclosure claims in deal litigation since then. And then finally, I'll share with you, time permitting, a few takeaway points from my perspective on the impact of these decisions, again, based on what's occurred over the last 4 years. So let's start with what Corwin itself was about and how it was decided. Again, maybe very basic for a lot of people, but you may not have read the lower court opinion as much as the Supreme Court opinion. And I have a unique perspective on the lower court opinion since I was the trial court judge. The case was on my docket when I became chancellor, as Ed mentioned, in May of 2014. And I issued the opinion dismissing the case less than 6 months after joining the bench. So a pretty significant case early on in my career. Fortunately, my ruling was affirmed in actually an extremely gracious opinion by the Supreme Court. But the affirmance did not happen in the way you might have thought it happened if you just read the Supreme Court's decision. Corwin involved a merger in which KKR acquired a company called KFN in a stock-for-stock merger in 2014. KFN was a specialty finance company that primarily invested in sub-investment grade corporate debt instruments, principally for KKR. It previously had been a wholly owned subsidiary of KKR, but it was spun out and taken public about 7 or 8 years before the proposed merger that was at issue in my case. At the time of that merger, KKR and KFN were both widely held companies, at least that was the record below, and KKR owned less than 1% of the stock of KFN. The primary claim in the case, as with many of the deal cases, is a claim for breach of fiduciary duty against the KFN board of directors for obtaining inadequate consideration in selling the company back to KKR. Defendants moved to dismiss for failure to state a claim under our Rule 12b-6. The plaintiffs didn't make any effort pre-closing to enjoin the transaction, So I have a motion to dismiss that I'm deciding in the context of after the closing. And my ruling, if you read it, really considers three questions. I'm going to walk you through the three questions I had in the order that I decided them. The first question, and the primary arguments that the plaintiffs made, was that entire fairness review should apply to the transaction on the theory that KKR was a controlling stockholder of KFN, despite owning less than 1% of KFN stock. That theory was based on the fact that KKR managed the day-to-day business of KFN pursuant to a management agreement for a period of time, making KFN operationally dependent on KKR, again, pursuant to the management agreement. After finding that the plaintiffs had failed to allege facts to support a reasonable inference that KKR controlled the board of KFN, which is the key inquiry under our case law, not the sole focal point, but the key inquiry, I rejected the plaintiff's first theory for applying entire fairness review. So that one's off the board. As a second line of attack, the plaintiffs argue that entire fairness review should apply to the transaction on the theory that a majority of the 12 members of the board of KFN who approved the merger were beholden to and not independent from KKR. And there was some force to this argument because many of the directors on the KFN board had relationships with KKR dating way back to when it had been spun out of KKR 7 or 8 years earlier. But after going through the allegations concerning the relationships of these directors, director by director as we do in Delaware, I concluded that the plaintiffs had failed to allege facts from which it was reasonably inferable that a majority of the KFN board was either interested in the transaction or not independent from KKR. Now, having rejected the plaintiff's two theories for applying entire fairness review, which meant that the business judgment review standard would apply, and we would defer to the judgment of the board, that could have been the end of my analysis. But I went on to address one additional argument, and I think I see the culprit in the room here that may have made me address that additional argument, Mr. Savitt. In hindsight, I think I might have been baited by some crafty lawyers at Wachtell Lipton who saw an opportunity to get clarification on a legal issue from a new judge who might feel he has to decide all the issues that were raised, every argument that the parties teed up. So whether that's true or not, I considered and ruled on the third argument that the defendants had advanced for the application of the business judgment rule, one that was done in the alternative had there been any taint with the board. That argument, of course, concerned the legal effect of the stockholders' approval of the merger by a majority of the stockholders unaffiliated with KKR. Now, at the time, it was an open question in Delaware law, at least in most people's mind, whether such a vote was required, when such a vote was required as a statutory matter under Delaware law, could ratify a transaction. And the confusion on that point came from a decision our Supreme Court decided in 2009 called Gantler versus Stevens, where the Supreme Court arguably drew a distinction between the legal effect of a statutorily required vote on a merger or a transaction versus a vote that was imposed just as a voluntary independent condition of a transaction. Some read Gantler to hold that the only kind of vote that could have a ratifying effect was one that was voluntarily imposed. So after surveying the law, I concluded that it did not matter whether the vote was taken was statutorily required or was a voluntary condition of a transaction, and that its legal effect would be the same in either case. And to be more specific, I held that the legal effect of a fully informed stockholder vote of a transaction that was required by the statute, in this case the merger statute, that did not involve a controlling stockholder was that the business judgment rule would apply and insulate the transaction from all attacks other than the grounds of waste, even when a majority of the board was tainted either by being interested in the transaction or not independent. That was the precise holding. The plaintiffs appealed that decision to the Delaware Supreme Court, which is not surprising. But what was surprising is the plaintiffs changed their theory on appeal in two ways to advance arguments they really hadn't made to me in a meaningful way. First, they argued that even if KKR was not a controlling stockholder and the entire fairness standard didn't apply, dismissal was unwarranted because Revlon should apply, which involves sales of control of a company, to the transaction. And if it had applied, as a practical matter, given the state of law at that time, that would mean they'd likely be able to take discovery to test the reasonableness of the KFN board's decision in approving the merger. Second, the plaintiffs now took issue with the meaning of Gantler, which they had sort of conceded below in terms of what its legal effect would be, and focused on whether or not all material information was disclosed. The Supreme Court comments in its decision on the impropriety of the tactics the plaintiffs use in advancing new arguments on appeal, but it didn't stop there. Instead, they used the opportunity to latch on to what, for me, was a tertiary, third-level argument as the basis for my decision in order to weigh in on the meaning of Gantler, and I think to change in a pretty fundamental way the way Delaware law was operating at the time. Using extremely long footnotes that ran for pages, were laden with case authority going all the way back to 1928. I think the Chief Justice's law clerks were working hard that day. The court firmly endorsed the following proposition, which is sort of the key holding in the case. When a transaction, I'm just reading a passage here, when a transaction is not subject to the entire fairness standard, the longstanding policy of our law has been to avoid the uncertainties and costs of judicial second-guessing when the disinterested stockholders have had the free and informed chance to decide on the economic merits of the transaction for themselves. In doing so, the court created this potential off-ramp I mentioned before for post-closing deal challenges where the application of intermediate scrutiny, enhanced scrutiny, under cases like Revlon and Unical previously had made it difficult, if not at times practically impossible, to achieve a pleading stage resolution of even ostensibly weak cases. Now, looking back at it now, it's really no surprise in my view that the Supreme Court, with Chief Justice Strine leading the charge, took this approach. Just 5 months earlier in Cornerstone, the Supreme Court revisited its prior precedent and provided another pleading stage off-ramp to permit, and this is in the Cornerstone case, the dismissal of outside directors even when the plaintiff had pled sufficient facts to invoke the entire fairness standard of review, unless the plaintiff was able to allege a non-exculpated claim for breach of the duty of loyalty as to each director individually, had to go director by director. And of course, just 1 year before that, just 1 year before Corwin, the Supreme Court affirmed then Chancellor Strine's decision in MFW that also provides a potential off-ramp at the pleading stage, but in the case of controlling stockholder transactions in cash-out mergers. I'm not going to get into that standard, but the point is the fabric of the law with these standards and how we evaluate cases at the pleading stages was being very much redefined in this era. So having talked about what the case is about, I want to turn to how courts have applied Corwin. Since Corwin was decided in late fall of 2015, the Court of Chancery has, by my count, considered motions to dismiss based on Corwin on 29 occasions. I want to discuss the results of those cases from two perspectives. First, from the perspective of how the case law has fleshed out the doctrine, and then second, from the perspective of considering the bottom line outcomes of those cases. Let's start with the doctrine. In the wake of any new doctrine, trial courts inevitably confront questions to work out the nuances of applying that doctrine. And our experience in the Court of Chancery with Corwin has been no different, and we now have the answers to many questions for which we weren't sure when the doctrine was first adopted. So here are some of the results. Corwin not only will apply to one-step mergers, it can also apply to transactions structured with a tender offer on the front end of a two-step transaction. That's the Volcano decision. Corwin can apply to aiding and abetting claims, and that's logically because the dismissal of the breach of fiduciary duty claim under Corwin eliminates the predicate necessary to prove aiding and abetting. In the absence of a controlling stockholder, Corwin can apply to loyalty claims that otherwise might have been subject to entire fairness review due to conflicts faced by individual members of the board. That actually was the fact pattern of Corwin itself below. Under Corwin, the burden is on the plaintiff to plead that the stockholder vote was not fully informed by identifying a deficiency in the proxy statement, at which point the burden then falls to the defendants to establish that the alleged deficiency fails to state a disclosure claim. That was a decision I issued in Solera, which the Supreme Court later endorsed in a footnote in some later decision. A plaintiff cannot avoid Corwin by attempting to dress up defective disclosure claims as a claim for quasi-appraisal because the underlying claim is substantively one for breach of fiduciary duty. And finally, when a motion to dismiss based on Corwin is denied with respect to a Revlon claim, the standard to be applied at trial will remain one of enhanced scrutiny under Revlon. Now, I want to focus on that last holding for a moment. Careful readers of the Supreme Court decision in Corwin may recall a passage where, and I'm just going to quote part of that passage now to set the context. It's stated as follows: although the plaintiffs argue that adhering to the proposition that a fully informed, uncoerced stockholder vote invokes the business judgment rule would impair the operation of Unical and Revlon or expose stockholders to unfair action by directors without protection, the plaintiffs ignore several factors. First, Unical and Revlon are primarily designed to give stockholders and the Court of Chancery the tool of injunctive relief to address important M&A decisions in real time before closing. They were not tools designed with post-closing money damage claims in mind, and it goes on. But in view of that language, many practitioners speculated that this passage foreshadowed that the Supreme Court would articulate a more restrictive standard than enhanced scrutiny to apply when adjudicating post-closing claims for damages for Revlon or Unical claims, and that did not come to pass. Instead, in the RBC or Rural Metro case, which was decided about 1 month later, but interestingly enough, without the presence of the Chief Justice on the case, the court endorsed the use of enhanced scrutiny to adjudicate a post-closing claim for damages. So now I want to turn a little bit to what have been the outcomes under Corwin. That's the doctrine. We know what the holding is. What's the bottom line of what's happened? Because I think this is sort of a key point. As I mentioned, there are 29 cases that have been decided under Corwin, and I'm going to run through them quickly year by year because I think you'll see sort of a pattern. In 2015, the Court of Chancery considered one motion to dismiss under Corwin. Obviously, there was only like 3 months left after Corwin came down, which it granted. And to be more specific, Vice Chancellor Parsons actually granted re-argument in the Zale case on the heels of the Corwin decision to dismiss an aiding and abetting claim against the financial advisor, which the Supreme Court later affirmed in the Singh versus Attenborough case. In 2016, the court considered 6 motions to dismiss under Corwin, all of which were granted. 3 of those decisions were appealed, all of which were affirmed. Now things start to change. In 2017, the court considered 13 motions to dismiss under Corwin. 10 of those motions were granted and 3 were denied. Of the 10 motions that were granted, however, 2 were reversed on appeal. This means that in net terms for 2017, 5 of 13 Corwin motions to dismiss resulted ultimately in denials. In 2018, the court considered 6 motions to dismiss under Corwin. 5 of those motions were denied, and only 1 was granted. In addition, the court denied a motion for summary judgment in another case where Corwin was invoked after finding the existence of factual disputes concerning whether stockholders had received all material information. And finally, through the first 6 months of this year, the court has considered 3 motions to dismiss under Corwin. 2 of those motions were granted, and 1 was denied. Of the 2 that were granted, 1 has been affirmed on appeal, and the other is pending on appeal. So to sum up, of the 29 cases in which motions to dismiss under Corwin have been adjudicated, 18 resulted in dismissals, and 11 did not. Now I want to take a look at the reasons for those outcomes where the motions to dismiss were denied or were reversed on appeal. And those reasons, as you might expect, logically break down into 3 categories that track the conditions for a stockholder vote to be effective under Corwin in the first place. Namely, that the vote's fully informed, that there's not a coercive transaction, and that the transaction doesn't involve a controlling stockholders. The most common reason, substantially so, for denying a Corwin motion concerns disclosure issues. Specifically, 7 of the 11 Corwin motions that have failed did so because of disclosure problems that prevented the stockholders from having a fully informed vote. And I think it's significant and very intentional, actually, that 2 of those outcomes were the result of Supreme Court reversals in 2018. Turning to the second category, I think my cell phone is buzzing, so I apologize. My wife should know better than to be calling me right now. And I don't know how to do I'm going to just turn the doggone thing off. Yeah, exactly. She should know what I'm doing. In any event, so if you turn to the second category, two were denied based on the allegation that there were not sufficient allegations to support a reasonable inference that the transaction, that it was inadequate, that there were sufficient allegations, that there was the existence of a controlling stockholder or a controlled group of stockholders. One was the Tesla case. I'm sure that's opening bad wounds for you, Bill. I'm sorry about that. But because there was enough pled for the existence of a control at the pleading stage based on the facts before the court, it comes out of the Corwin framework. So there's two cases to that effect. And in the final category, there are two cases where the Court of Chancery determined that it had been sufficiently pled that the stockholder vote was coerced, again, to render the Corwin inapplicable. In one case, it was an issue of situational coercion, as the court characterized it, where in the court's view, the stockholders had no practical alternative but to vote for the proposed transaction. And in the other case, the court found structural coercion, and this is a significant point I think we may see in more cases, where the vote to approve the transaction was tied to and resulted in the approval of unrelated transactions that favored an insider. So having laid out those statistics and the rationale that the cases have survived, what did we learn from that? And I would make three observations. First and foremost, Corwin has not been the showstopper to deal litigation that many practitioners and academics feared it would be. It is not surprising that there was a streak of dismissals early on in 2015, late 2015 and 2016, in my view. Most, if not all, of those cases were in the pipeline, if you will, of the court's docket when Corwin was decided by the Supreme Court, and likely, frankly, caught the plaintiffs off guard. But if you back those first 7 cases out, the numbers show that the court has decided 22 dismissal motions over the last 2.5 years under Corwin. That's 2017, 2018, first part of 2019, 11 of which, or half, have failed. And that's hardly a show-stopping doctrine. Second, and related to the first point, plaintiffs' lawyers have become more effective pleading cases to survive Corwin review, and that's principally by using Section 220, our Books and Records statute, in order to plead stronger cases. In fact, most of the 11 cases that have survived Corwin dismissal motions, including the 2 cases in which our Supreme Court reversed Corwin dismissal motions, reflect that the plaintiffs obtained documents through the use of 220 that they used to show that material information either was omitted from or misleadingly disclosed in the proxy statement. The path for using Section 220 for this purpose was endorsed in 2017 in a case called Lavin versus West Corporation, where the court rejected, as a matter of law, the argument that was made that Corwin stands as an impediment to an otherwise properly supported demand for inspection under Section 220. Now, having said that, there is a reality that a stockholder plaintiff has to move quickly, has to act with alacrity to exercise this right by filing a Section 220 case before the merger closes so as not to lose standing to be able to bring a Section 220 claim. And the third observation I will offer is that there seems to have been a decline since 2017 in the number of Corwin decisions or Corwin motions that the court's been deciding. I don't know if that's going to continue or not, but I have a suspicion it relates to the second part of what I want to talk about now, which is the Trulia decision. Excuse me. As I'm sure everyone in this audience is aware, when I issued my decision in Trulia in January of 2016, virtually every transaction involving the acquisition of a public corporation resulted in a flurry of class action lawsuits alleging that the target boards of directors breached their fiduciary duties by agreeing to sell the corporation for an unfair price. Between 2005 and 2016, the percentage of transactions of $100 million or more that triggered stockholder litigation had more than doubled from 39.3% in 2005 to 96%, which is the high watermark in 2013. On average, over 90% of deals were the target of lawsuits between 2009 and 2015. Parties often resolve these lawsuits by agreeing to what we've been calling disclosure-only settlements. In these settlements, the target company would agree to include some additional information in the proxy materials that were disseminated to the stockholders before they voted on the proposed transaction. The theory, of course, is that those supplemental disclosures would allow stockholders to be better informed when exercising their franchise rights, but the reality suggested very much otherwise. In a study published in 2015, Professors Fish, Griffith, and Stephen Davidoff Solomon presented empirical data suggesting that supplemental disclosures made no difference in stockholder voting and did not provide a benefit that could serve as consideration for a settlement. Yet from 2005 to 2015, plaintiffs' counsel extracted attorney's fees in disclosure-only settlements ranging up to about $600,000 per case, with a median payoff of approximately $300,000, and thus imposing what had been characterized in the literature as rents or deal taxes on virtually every M&A transaction. The leverage, of course, that the plaintiffs' lawyers had to pull this off was to seek to threaten a preliminary injunction or to bring a preliminary injunction to enjoin the transaction from closing until supplemental disclosures had been made, putting a cloud over the deal. In exchange for dropping that threat, plaintiffs obtained the supplemental disclosures that they desired with the expectation of seeking a fee for those efforts and agreed to provide the defendants with a release of claims on behalf of the proposed class. Typically, the breadth of these releases far exceeded anything having to do with what was really at issue. For example, the release in the Trulia case encompassed, among other things, unknown claims and claims arising under federal, state, foreign, statutory, regulatory, common law, or other law or rule held by any member of the proposed class that in any way remotely related in a conceivable way to the proposed transaction. There were also real downsides to giving these releases because they could cut off potentially valuable claims. Mr. Friedlander in the audience here knows all about one that I'm going to mention now and that I mentioned in Trulia, which provides a good example of this. And that's in the Ruhr Metro case. A stockholder objected to a proposed disclosure settlement to which the original plaintiffs had agreed. During the settlement hearing, Vice Chancellor Laster considered it, quote unquote, a very close call to reject the settlement. Had that settlement been approved, over $100 million in payments that later were obtained for the class never would have been realized. In addition to providing no real value to stockholders and threatening the loss of potentially valuable claims, disclosure-only settlements presented significant challenges for the court because the settlement hearing often was the first time the court would see the case and have any contact with the case, and the hearings were typically done in a very non-adversarial way. Although it happens on occasion, it is relatively rare that a stockholder, another stockholder other than the one that's the plaintiff in the case, will take the time and make the effort to object to a proposed settlement. The lack of an adversarial process required that the court probe the value of the get in the get-give equation for the stockholders without the benefit of opposing viewpoints. A horrible way to run a court. Indeed, the court essentially became a forensic examiner of proxy materials so that it could play devil's advocate for probing the value of the supplemental disclosures. I have many a vivid memory of sitting in a conference room early on with a law clerk, poring over proxy materials before a hearing, only to find that things that lawyers were telling me weren't in the proxy actually were in the proxy, or that things that were putatively valuable supplemental disclosures simply repackaged other information that was already in the proxy as well. So given the concerns I've just discussed, the court began to re-examine its historical predisposition toward approving these kind of settlements. In 2014 and 2015, several judges on the court had rejected some settlements, including the chancellor at the time, Chancellor Strine, as unreasonable, and others had cut fees in cases that yield little, if any, benefits for stockholders. But the practice continued with no real signs of letting up. And that's the context in which I decided the Trulia case. Trulia just simply formulated a new framework for evaluating these kind of settlements. It expressed a preference for disclosure claims to be litigated in a true adversarial setting or to be mooted, thereby keeping the adversarial process intact as well, and I'll elaborate on that in a minute. It did not rule out approving in the appropriate case a disclosure settlement, but it sent a message that they would be scrutinized much more rigorously than they had been in the past. And the critical passage of the opinion, I'll just read now, sets that up. It states, practitioners should expect that disclosure settlements are likely to be met with continued disfavor in the future unless the supplemental disclosures address a plainly material misrepresentation or omission, and the subject matter of the proposed release is narrowly circumscribed to encompass nothing more than disclosure claims and fiduciary duty claims concerning the sale process if the record shows that such claims have been investigated sufficiently. To be clear, in using the word plainly material, it was not my intention, or the court's intention for that matter, to change the legal standard for what information must be disclosed to stockholders. That standard remains one of materiality under Delaware law, which in turn just tracks federal law. Rather, as I explained in Trulia, the term plainly material was intended to make the point that when we have to evaluate as judges the fairness of a settlement by looking at the give and the get of a settlement, it really shouldn't be that close of a call when we're looking at supplemental disclosures. So what's happened since Trulia has been decided? In the post-Trulia world, I'm going to look at this, I think, in the same way I looked at Corin, really by looking at two different points. First, by providing some statistics on the deal case filings, and second, by reviewing what courts in other jurisdictions have done when considering disclosure settlements after Trulia. On the statistical front, again, I want to acknowledge the excellent work that the professors I mentioned before have done with the help of two other professors, Matthew Kane and Randall Thomas, in examining disclosure settlements and the resolution of deal cases. The statistics I'll share with you come from two of their recent articles and from Cornerstone reports that have been, that just came out recently, actually. And the trends that have emerged are quite striking. Some of them everybody knows, some may be a little more obscure. And I'm going to highlight four of them. First, I suspect everyone has this one figured out by now, there's been a clear flight to federal court in deal litigation and a concomitant decline in the filing of such cases in the Court of Chancery. So in 2015, pre-Trulia, 60% of all litigated deals faced a challenge in Delaware versus 19% in federal court. By 2018, well after Trulia, 5% of litigation deals faced a challenge in Delaware versus 92% in federal court. The shift from Delaware is really not a surprise to me. I anticipated this was likely to happen, so long as other jurisdictions are unwilling to clamp down on the settlement practices our court found so troublesome, there will always be lawyers who will look for another place to file those kind of cases. The shift to federal court also is logical, given that the increased adoption of forum selection bylaws can limit the ability of plaintiffs to file in other states, but cannot preclude the filing of federal claims in federal court, of course, because in particular with 14A claims, they can always be brought in federal court. Second trend, and this is the one I didn't quite anticipate to the extent it has occurred, parties now resolve deal litigation primarily through voluntary dismissals after defendants make supplemental disclosures that the plaintiffs request, and the payment of mootness fees instead of pursuing disclosure settlements. Indeed, disclosure settlements appear to have virtually disappeared. So consider these statistics. Out of 124 cases challenging deals that closed in 2015, before Trulia, 46% of the cases settled, 54% were dismissed, that gives you the 100%, and then 14% resulted in the payment of a mootness fee, which obviously would be within one of those two first categories, presumably the dismissed. By contrast, out of the 135 cases challenging deals that closed in 2017 after Trulia, 9% settled, 91% were dismissed, and 65% resulted in mootness fees. And out of 120 cases challenging deals that closed last year in 2018, 0% settled, 100% were dismissed, and 63% resulted in the payment of a mootness fee. Now, the number of settlements in 2017 and 2018 are likely to be unrepresented in those figures because some of these cases are still pending, but those trends nonetheless are extremely dramatic. And you may recall that the Trulia opinion supported using the voluntary dismissal mootness fee route as an alternative to a disclosure settlement. And that's me. I did support this because the process doesn't involve providing a release, and it will preserve the adversarial process if the court is asked whether a fee should be awarded in a case. As I pointed out in Trulia, however, if the parties come to agreement on a fee, that obviates the need for judicial review. But, and this is an important but, in Delaware at least, we require disclosure to the stockholders of the entity paying the fee to ensure that there is sunlight on that process and to prevent against abusive buy-off payments. Having said that, I must say the magnitude of the shift from seeking court approval of disclosure settlements to voluntary dismissal mootness fees has really surprised me, that it's literally gone full tilt the other direction. Third, the overall percentage of deals challenged has declined, but modestly. In 2013, which as I mentioned was really the high watermark, it was 96% of deals over $100 million that were challenged with at least one lawsuit, typically 3 or 4 lawsuits. And the number of lawsuit challenges is down, but the percentages have declined, but only modestly. So in 2016, went right on the heels of Trulia, it was down to 74%. But now it's leveled off so that in both 2017, 2018, 83% of deals. Fourth and finally, there's some representatives of the plaintiffs' firm I'm not going to implicitly criticize in the following comment. There really is a relatively small group of plaintiffs' law firms that appear to be responsible for the vast bulk of these cases that are now filed in federal court. In 2017 and 2018, about 6 firms filed a highly disproportionate number of these cases. It's simply a cottage industry. And those firms, I will say, are not the ones known in Delaware for actually achieving meaningful damage recoveries for stockholders. So now I want to turn to the legal developments with Trulia. So in writing Trulia, I fully anticipated that its effectiveness ultimately may depend on whether other jurisdictions would adopt a similar approach given the natural inclination of lawyers who specialize in disclosure settlements to shop for a more hospitable forum. And to simplify things in the interest of time, I'm going to go over the cases and just group them in 3 categories. The first category consists of jurisdictions that have adopted and applied the reasoning of Trulia. And foremost among them is the Seventh Circuit's decision in the Walgreens case, which explicitly adopted the plainly material standard of Trulia. And in his obviously talented and inimitable way, Judge Posner was able to put into 2 sentences what it took me many, many pages to explain about the need to apply heightened scrutiny to disclosure settlements when he said, the type of class action illustrated by this case, the class action that yields fees for class counsel and nothing for the class, is no better than a racket. It must end. Well, I wish somebody had given me those words before, and I guess I spared myself a lot of pages because it sort of gets to the point very quickly. Following Walgreens, 2 districts in the Seventh Circuit, one in Illinois, one in Indiana, both have rejected disclosure-only settlements by applying the Trulia standard that Walgreens endorsed. I think one of those may be on appeal. At the state court level, courts in California, Connecticut, Florida, and New Jersey have adopted the reasoning of Trulia. Most of them have done so in the context of rejecting a disclosure-only settlement, although Connecticut, in one case, approved such a settlement after finding that the supplemental disclosures were plainly material. That's category 1. Second category consists of jurisdictions that have discussed but declined to adopt Trulia's call for heightened scrutiny. That occurred in Tennessee and most notably in New York. Specifically, as the New York lawyers in the room will know, in Gordon versus Verizon Communications, the First Department of New York, the New York Appellate Division, and opinion, I must say, I had a little difficulty trying to understand what was going on, declined to adopt the reasoning of Trulia and purported to reformulate a 5-factor test called the Colt factors that it had into a 7-factor test. And after they had a 7-factor test and applied it, they determined that supplemental disclosures that provided only some benefit to stockholders were sufficient to warrant court approval of a proposed settlement. Significantly, from my perspective, there appears to be some tension within New York, the New York state courts concerning that approach. In City Trading, the City Trading Fund versus Nye case, Judge Kornreich of the New York Supreme Court observed that although Gordon's sum benefit test is less stringent than the plain material standard in Trulia, there is no reason why that test cannot be interpreted to have some teeth. And then the court went on to say the following, which I took some solace in. It is no secret that the commercial division strives to develop a reputation on par with the Chancery Court. To do so, our corporate law must be considered as savvy as Delaware's. Developing a reputation for attracting and countenancing worthless strike suits accomplishes the opposite result. The third category of cases is a big smorgasbord of cases that neither fully adopt nor decline to adopt Trulia. And those cases take a variety of approaches, ranging from applying sort of a slightly less stringent version of Trulia, but something a little more than the sum benefit kind of test, citing Trulia favorably, but stopping short of fully adopting it. That happened in Michigan, which had its idiosyncratic reasons for doing so, as well as in North Carolina, which has actually issued several decisions, to finally, continuing to approve disclosure-only settlements without even mentioning or discussing Trulia or any of the cases since Trulia that have criticized the practice. One approach I found particularly amusing comes from the Federal District Court in my own state. Confronted with disclosure-only settlements in two of his cases, Judge Andrews, this is a District Court of Delaware, Federal District Court of Delaware judge, gave the litigants two options. Option one was that each party could retain an expert to submit a report and to testify as to the significance of the disclosures, with an evidentiary hearing to be held thereafter. Option two was that the court would appoint an expert to assist him in deciding whether the disclosures conferred a substantial benefit to the stockholders. And under the second option, the parties would split the cost of the expert, but the prevailing party would be allowed to recover its cost from the loser. Now, to no surprise, both of those motions were withdrawn and dropped in those cases after that practical solution, I guess. So to close out, how am I doing on time here, Ed? I'm all right? 2 more minutes? To close out, I'm going to leave you with 2 final observations from my perspective on the aftermath of Corwin and Trulia, based on this 4-year experience that we've seen. And the first is on Corwin. For over 100 years, Delaware courts, Court of Chancery and the Supreme Court, since it was established as a separate institution in 1951, have crafted a deep body of common law that attempts to balance, at its core, the economic and societal benefits of affording businesses the freedom to take risks and make decisions without judicial second-guessing, against the need for guardrails to protect investors from exploitation and self-dealing. That's fundamentally our mission. And we accomplish that mission in a significant way by crafting and applying standards of review situationally to evaluate the conduct of fiduciaries. Corwin, as I see it, is simply an evolution of our standards of review that affords a potential pleading stage off-ramp to non-controller deal litigation where the stockholders have ratified a transaction free of coercion after receiving all material information. One can legitimately debate whether relying on the outcome of the stockholder vote is the best gating mechanism to use at the pleading stage to decide which deals should proceed to discovery and which should not. And discovery is very expensive. That's a legitimate debate Ed Rock has written about, and many others in the academic community have written about, given the reality of institutional share ownership, institutional voting behaviors, the motivations and influences of arbitrageurs whenever a deal is announced, and a whole host of other factors that are beyond the scope of what I'm going to talk about today. My point is that if you accept, as I think most people do accept, that there should be some gating mechanism before a post-closing deal case for damages should move into discovery, which, as I said, is a very expensive enterprise, the record shows that Corwin has not become a lopsided, one-sided affair, and at least at this early stage, seems to be performing the gating function in a balanced manner. My second observation concerns Trulia. In 1996, Chancellor Allen famously remarked in a case called Solomon, I don't know if it's PATH or PATH-A Communications Corporation, the following: it is a fact evident to all of those who are familiar with shareholder litigation that surviving a motion to dismiss means, as a practical matter, that economically rational defendants will settle such claims, often for peppercorn and a fee. And as brilliant as Bill Allen was, I'm not sure that even he could have imagined the explosion in disclosure-only settlements that occurred over the next 20 years after he wrote those words and led to the Troya decision. The refusal of the Court of Chancery to abide the status quo that culminated in Troya had to happen, in my opinion, as a matter of good corporate hygiene, if nothing else, and even if it did come at the cost of having lawyers take cases elsewhere. And now, having essentially 4 years of cases to grade our performance, I'm generally pleased to see that courts in other jurisdictions largely seem to agree with Troya. Virtually nobody argues against the idea that there needs to be a higher level of scrutiny, with one or two notable exceptions. And the practices have shifted from a world of disclosure-only settlements in a non-adversarial setting to one of voluntary dismissals without releases. A concern I do have, though, is that the mootness fee by agreement approach, outside of the by agreement approach, I should say, appears to be occurring in federal courts and perhaps other jurisdictions without any disclosure to stockholders of the type we require in Delaware. Sorry, misspoke. I'm talking about the context where it is by agreement. If people can't agree, comes to court, we decide the mootness fee. Makes perfect sense. That will be adversarial. The company always has a choice. I don't want to pay mootness fee. I'll fight it out. We can figure out the merits. But if they agree, which is fundamentally an issue that Delaware law views as a business judgment of a corporation to decide, do I want to pay a fee to get rid of a lawsuit? That's presumptively a business judgment rule decision. But in problematic cases, and they can arise, where there's circumstances suggesting it could be a buy-off or some bad practice, there needs to be some sunlight on that process. And that's why long ago, Chancellor Allen, in a case called Advanced Mammography, required as a condition of a mootness fee situation, when it's done privately by parties, that there nonetheless must be disclosure to stockholders. We do it in Form 8Ks. We adhere to it rigorously today. But I have a great concern that process is not adhered to in many other courts where the mootness fee practices have really gone full throttle. And that is a concern I hope that they'll take action to change, whether it's by case law and perhaps legislatively, particularly in the federal courts. I think it would be in order. Those are my comments, and I thank you for your time and patience. Well, thanks. Yeah.
Questions for Mr. Chancellor? Come on, students. Jennifer.
Sure.
But I'd rather
No. Take your first.
So I was trying to get you primed. So I was curious about whether you thought, maybe an unfair question,
Yeah.
but the court that decided Tesla, particularly in light of the new cases, the recent cases on what counts as an interest or a conflict on the board. I mean,
Yeah.
it's really been an expansion on how deep we look. Loyalty, I gave you my first job, and those kind of issues.
Yeah.
Would take the same approach to the fundamental question in Corwin, which was, did KKR have control or domination? And would it take a different approach?
If you're asking, I mean,
Might
it's-
KKR have looked like a controlling shareholder to
Yeah.
the Tesla court?
No, I mean, I don't know I don't know all the facts in Tesla, and I'm not going to comment on Tesla because there are variations of that case that's pending. But I know its stock ownership threshold is significantly higher than I mean, it's in the 22%, if I recall correctly, something in that ballpark, and that's a different place. You're literally talking under 1%, KKR had at the time. There were also like 7 or 8 stockholder meetings that occurred between when it was spun out and the time of this transaction, when people, had the chance to change the board a whole bunch of times. So it was just sort of a bread and butter analysis for each of these directors. Are they beholden for some reason based on the inferences you can make from the facts that are pled? They didn't really have any unique financial interest in the transaction per se. They were similarly situated to everybody else, if I recall correctly. No question that we apply more rigor, I do, now, in examining independence questions, and particularly when controllers are involved. For, I think, a lot of good reasons. I wrote a decision recently called the BGC decision that discusses some of that. particularly in the Rule 23.1 context. If I were applying the more, robust, if you will, let's assume it's more robust hypothetically, standard that recent times seem to be applying, back to the KKR facts, it would come out the same way. No, I don't think there's any question on that. The more interesting question is, I didn't really discuss it in terms of being an LLC. It wasn't really teed up that way. LLCs can have some different considerations in their governance structures. The real issue was, whereas there's such a chokehold by virtue of contractual arrangement that they just, maybe they didn't have a lot of stock, but they operationally had control over this company. And that's really not the key focal point. I mean, there's some subsequent cases that have elaborated, like the Basho decision by Vice Chancellor Laster, elaborate on like several different factors you consider in control now. But the case law, as I read it as the time of KKR, was really a focus on a board-controlled decision. And if the board had optionality to reject the deal, and they certainly did, potentially pursue other alternatives, but they candidly were limited because this was always sort of spun out as something that was going to do a lot of work for KKR and they would manage, and everybody knew it up front. But they had the power to say no to a deal. And when you look at control of the board as the primary consideration, I would have come out the same way anyway.
Other questions?
I'm sure Bill Savitt's relieved.
Hi, thank you. So I was just wondering, when you're thinking about the disinterested shareholder vote, do you consider and should you consider how sophisticated that firm's shareholders are?
Well, like I said, and that's sort of beyond the scope of my talk, we don't. We look at a number. It is the balance after you remove the controller. And I'm not looking at individual shareholder profiles to make some assessment of institutional ownership, savvy stockholders. We're just looking at a number, a percentage. Should we do it differently? It'd be a very hard thing to do as a practical matter. And maybe this is a larger conversation. Implicit in looking at this variable, we are, I guess, assuming some level of sophistication or that it really is the will of the people that own the company. But we don't look further.
Thank you.
Yeah. All right.
Let me ask a question.
Yeah.
So, we have a disinterested board making a decision on a deal.
Yeah.
The first defense is business judgment. The second defense is 102B7.
Yeah.
And one might have thought those were sufficient defenses, and certainly if you got to trial, they would be sufficient defenses, I would say. And even if you get the summary judgment, they're probably sufficient defenses. And do I take you to be saying that the big innovation of Corwin is that it means you're able to dismiss the cases where you don't think there's a problem at the pleading stage rather than in your summary
Well,
judgment?
in the Revlon Unical context, I mean, if it was, the true stock-for-stock merger, you would be in a business judgment rule case. But if you have a Revlon circumstance where you're buying control, taking out the shareholders for cash, it's enhanced scrutiny, and which is reasonableness. You're measuring the reasonableness of director's judgment. It's not too hard to plead a case on reasonable conceivability as our pleading standard
Even
to
when-
get past a
even
motion
when
to
it's a
dismiss.
Post-merger damages act?
Yes. I mean, that was the whole point. It wasn't that difficult to plead a case that would get you past a motion to dismiss. And I think the point of Corwin, I mean, Chief Justice here, he can tell us what he thinks, but I think the point of Corwin is if you have the vote behind it and it has this ratifying effect, and many old cases have taught along these lines, you should get business judgment protection. And it works, I think, most effectively in the context of Revlon and Unical cases. Business judgment rule is business judgment rule. That's not an issue. It's really when you have higher scrutiny. And it can even work, like I said, in the Corwin fact pattern itself, if a majority of the board was interested, and it would be presumptively entire fairness, you have to disclose all those facts. Most people don't disclose all their conflicts, all their dirty laundry, but if it's all out there and they make the choice, then you can get business judgment review.
Any more questions? Or shall we adjourn and have a drink? Please join me in thanking.
Yeah, my pleasure.